You want to try your case. You want to have your case heard in front of a jury to determine your guilt or innocence. And to do that, you've gone through all the bells and whistles, you've gone through motions, you've gone through a whole bunch. Chances are you've either been in jail close to a year, maybe a year, if you didn't have money. If you had money and you've been out of jail, then this case might have been dragging on even longer in some instances. You want to go to trial. The first thing that happens on the trial date is you pick a jury. Room comes in, different courts do them differently, but more or less the attorneys and the judge will go through this process called voir dire, where they question the jury to try and find out, the goal is to find out the biases of jurors, to find out if there's anyone that might have prejudices that would be harmful to your position on the case. I mean, this is, some people say, where trials are made and won or lost is in the jury selection. Is who are you getting? Who's that pool of people up there that's going to decide your fate? So you're paying attention to every nuance, tick, every word, where they blink, when they move, why they move. You want a jury up there who's going to be more favorable to you than the other side, hands down. There's books and books written on, studies on how to do this. So you go through this, which may take a half a day, may take a whole day to pick a jury. You're going to start with opening arguments. Opening arguments, the burden of proof is on the state. The state needs to prove your guilt beyond a reasonable doubt. These are the things that would take place in voir dire, and it's explaining what reasonable doubt is, explaining what proof beyond a reasonable doubt is, and there's all kind of different examples. Basically, it's the highest threshold of proof required in the United States. It can't be anything more strict, and it's like that for a reason, and that's because there's nothing more at risk than this person's personal freedom, possible life. So it's a high threshold to prove. At this point, you do opening arguments where you are supposed to, and these are textbook, like I said, theory. Theory and practicality are not always the same thing, but theory is opening statements is the DA gets to go first. They'll speak about why you're guilty, and here's the roadmap on what they're going to prove you did. And then we would get to go. We would get up and give our explanation of why we think you're not guilty, and what we're going to prove them wrong. A good statement I was told a long time ago is somebody walked up and said, "I'm not here to prove my client's innocent. I'm here to prove he's not guilty." There is a difference, and there is. So after both sides give their opening arguments, the state then gets to go and call their first witness. And they get to put on their evidence, call witnesses to testify, introduce pictures, photographs, whatever, to prove you're guilty. And every time they get to put a person up there on the stand, we get our turn to cross-examine their witness. So if they put someone on the stand to say, you did X, Y, Z, we get to stand up and say, well, isn't it not true you're blind in one eye and you are from another planet, whatever. We get to cross-examine. And then they get to rehabilitate, and it goes in order, over and over, until their last witness. When they're done, now we have a right to start calling our witnesses. Now, you might remember another video about self-incrimination. Most attorneys never put their own client on the stand to testify at their case. And that's to prevent you from possibly incriminating yourself any further. And there's a big fight here. There's actually a little struggle with whether or not you put your client on the stand. Some clients are adamant they want to tell their story. Some of them are better left not talking and just sitting on the side. When it's your life at stake, it's a tough decision because you are going to know your case better than anyone else. And whether or not you take that stand is sometimes very risky. So at that point, we get to put on our case. And bearing in mind the whole time, the burden of proof is on them. So all we should be doing at this point is defending every shot they took at us. Then they have closing arguments. Closing arguments is another aspect I think cases might be won or lost. That is where you get to talk to the jury and explain your events, sum it up, and give your version, and hopefully your version is the one that the jury believes, because after the closing arguments are done, the jury will go deliberate, and come back and make a decision to render guilt or not guilt. Sometimes it's guilty to a lesser crime, and sometimes they can't come up with a decision and it's a hung jury, but they come back to render a decision most of the time either guilty, not guilty, or guilty of something lesser, and at that point the judge will sentence. A lot of people don't realize that part. The jury does not sentence, the judge does, which makes it irrelevant for me to argue to a jury how much jail time my client might get, because the jury's not responsible for the sentence, they're responsible for the verdict. So I can't tell the jury that if you make this person guilty, if you came back with a verdict of his guilt, he's going to jail for 20 years. And I don't know, I tend to think that that's pretty relevant to the jury, but in fact, they don't. The jury's not the one who sets the sentence, the judge is. They're determined guilt or innocence.